When you enter an agreement of sale, from the date of entering the agreement of sale and to the date of registration, if there is a price rise, if there is an escalation in the price, then you will be at a loss and you wanted to cancel the agreement of sale, which is not possible. Law doesn't permit the cancellation of agreement of sale on the ground of rise in prices. Today I am going to share with you a technique which, if employed, taking the guidance from the Honorable Supreme Court in case Vidyanadam's case. Supreme Court in case Vidyanadam's case said that price rise from the date of agreement of sale to the date of registration must be considered. Of course, on a different ground, Supreme Court considered the price rise because there was a delay of 2.5 years by the buyer. Therefore, Supreme Court took notice about the rise in the price. But without such delay, without 2.5 years delay, the price rise can be considered if this technique is employed. When an agreement of sale is entered, the purpose of selling the property must be categorically mentioned. Broadly, there could be two kinds of purposes. One is for necessity, the other is for better price, for reinvesting in another property. So if these two conditions are incorporated in the agreement of sale, the first is necessity, the second is price rise. Either one of the condition must be there, both can't be there. If the price rise is included, if the better price, the clause pertaining to better price is included in the agreement of sale, then if there is a rise in price from the date of entering the agreement to the date of registration, you can cancel the agreement. The only technique is that you must categorically mention in the agreement of sale that you are selling the property because you are getting a better price. On the price point, you are selling the property. Then you can cancel the agreement only on the price point. That is only if the price is escalated, only on the ground that the price is escalated. If you take the ground of necessity, because of necessity you are selling the immobile property, then the buyer is never at an advantage. Then the alternative clause will be the forfeit clause. If price rise or a better price clause is included, forfeit clause can't be included. If you include forfeit clause also, it will be ignored by the court. But if necessity clause is included and you then include a forfeit clause will get more importance. The seller will be entitled to forfeit the advance money or the margin money if necessity clause is included. So every clause has its own advantages and disadvantages. But this video I am making to help you to understand the technique of cancelling the agreement of sale, or if you are getting a better price after entering the agreement of sale. For that, what you must do is you must incorporate a clause that better price you are getting, that is the purpose for which you are selling the property. You are not selling the property for any necessity, you are selling the property for reinvestment. If you make that clause in agreement of sale, then you have a case for cancelling the agreement of sale when you get a better price from the date of entering the agreement to the date of registration. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.